અને હરખું ચોખ્ખું લખવું એમ. કન્ડિશન નંબર ઈ છે પણ એટલે કન્ડિશન ઈ કદાચ એ જ હશે. એવું ના હોય, કન્ડિશન 2 મૂકેલી હશે તમારી. હા તો અગાઉની જેમ ઓર્ડર કરજો 6 મહિનાનો. તો તમે તો 5 વર્ષના માંગો, મને શું વાંધો છે? અગાઉની જેમ 6 મહિના. પછી ભાગી ગયો તો વચ્ચે ભાગી ગયા હતા ને ત્યારે, એટલે તમને ખબર હોય ને. બધી ખબર છે. પછી પૈસા ભરવાનું કીધું એ નથી ભર્યા. બોલું 36 ને 38 લાખ ભર્યા, ઈ ભર્યા, પછી નથી ભર્યા. પણ તમે એની સાથે રહેતા જ નથી. જયારે બહાર હતા ત્યારે નથી રહ્યા. વિથ ધ ક્વેશ્ચન Yesterday I was on humanitarian ground, I was to consider. But now this statement that you are not residing with your mother and the entire expense is borne by your father. And looking to your past conduct, then you are not entitled to. And you also not deposit the amount as per your. And then argue that no such condition could have been imposed by the court. હાલો, ઘણી બોલાવી કરી દે. It was within the competence of collector. It has been spoken for it is within his competence, but the decision of regularization, the required procedure is required to be followed. That procedure I have not informed. Your Honor, there is another question. There was another question. Whether we are not agriculture, Your Honor, in this instance, we have to put it big. On page at page number 4, third point. Page number? Page number 4, third point. I'm getting the copy. We just point out the number from the chart sheet so that we have this record here. Which is that witness? PW 43. Yes. What is his name? He is Mr. Amit Chaudhary. Yes. So page number 4. Yes. Other than this, statement has been argued. किसका कबूलतनामा? Yeah. Have the land. Okay. Yes. Your Honor, next question was whether he is intentionally lower down the area. Whether it's lower down the area. The area has been subsequently lower down, Your Honor, and permission has been granted for that particular area. It is our submission, Your Honor, that it appears from the report. Your Honor, you get PW 43, the statement of PW 43 itself states that on such and such date, application has been bought, applicants have been bought, same day letter has been decided, and after that, upon the application, which has been given by the applicant, where I have highlighted every topic on which I have given. Or that how on the first day that it is that
नीचे कम नीचे कम कम नीचे here
other than another very large whether the transfer of national product department or the institutions having motor statement and we are going to find
yes
here the institution is using the record or the department process. This statement that the nothing of government of land to the foreign currency including for this also be related to you know another query regarding section 30 with respect to 30-month pay and the application of PCS on the whole condition. You know, section 30 of PCS.
PCA yes
It says that if one on the field of condition misappropriate or otherwise convert for
हाँ बोलिए you continue yes I am hearing you
fraudulently misappropriate for otherwise convert by his own use any property invested in him or any property under his control as a public servant or allow any other person to do. Your Honor, here it specifically says that where there is investment in a public servant and he allows any other person so to do that the provisions of this section and that's why the challenge that accused person having charge that is our other than this, Your Honor, there was another very is there any proof in reference to consideration? Though there is no any direct evidence, but Your Honor, it appears from very from the case of reform that how the application can be disposed of. Other than this, Your Honor, I would like to submit one document to Your Honor. That is the application of applicant Your Honor. That is D63. Applicants. When the
okay
data in reference to allotment liability. Your Honor, it appears from this application that person has been typed, and after that, something has been written
47
by hand.
B63 P47.
What has been written by hand, Your Honor, what is there in handwriting? That is the area. That is the particular area. Which have been requested to be allowed.
Yes.
It has been submitted, Your Honor, that those people are evicted.
So
Then, if thinking, Your Honor, that they are not having that much knowledge related to calculation. Then it's Your Honor, they will visit what language such as application. They will ascertain in family that, you know, and whatever has been written in handwriting, Your Honor, that has been subsequently and intentionally that area have been ascertained. Your Honor, the handwriting both have been similar handwriting.
who has decided it? Who has decided it?
Your Honor, it appears from
It appears as per your impression.
that
But-
is our.
You may submit anything, but submit it. So this is what you want to point out by saying that some handwritten part is written, though they are illiterate. They have put their signature. Oh, so did any one of these applicants say it? No, no, this we have not written. First, you listen to the court. When you are putting an argument, some arguments I am not able to accept it. Then you should satisfy the court why your argument should be accepted. Don't continue to whatever you are. You raise the contention that this handwriting was subsequently made because they are illiterate. Now, on what basis you are saying? Did you ask that applicant, is this your handwriting or not? Because it bears the signature. You don't have any evidence. You can ask your IO, but if don't imagine anything. Now you are not an IO. It is already circumstances. Now you don't create further circumstances beyond which, as per your imagination. We can't imagine. We are for discharge. What is the evidence? If it was found in the mind of IO, then you should verify. You should have verified who has written this application. Now, who said it? This is not written by Suresh by Lakshman Bhai. Just point out when you are raising an argument. Hmm.
उन्होंने अलग अलग एप्लीकेशन जो है वो फाइल किए हैं वर्डिंग सेम है ना एरिया को क्लेम है सेम ये हमारा
वो तो है एरिया सेम, उसके बेस पे आप आर्ग्यूमेंट क्या फ्रेम करना चाहते हो? राइटिंग का तो कोई है नहीं, वो तो एप्लीकेंट ने नहीं बताया किसी ने कि so you want to contend that the area was intentionally lowered down
Yes, sir.
at the instance of this accused because the applicants were not aware about he has power to give particular area only. So therefore it was here for their instruction. This application was made once again, and thereafter this handwritten area was also fixed. Same area has been written just to bring that power of the collector within his power. Otherwise, it was going beyond 2 lakh. An area was something little bit larger. Okay. And therefore, this is the circumstances. Yes.
Other than this, I would like to Okay. You are 3104. It's page number 3122. It's page number 2 and 3. Entry number 7. You are.
114 or 104?
You are, it is T104.
Okay, yes, page number.
Page number 2. You are. Serial number 7.
Serial number.
7. You are. Reply of your honor, some certain issues which have been raised by the CBI and which have been explained by the Revenue Department. On issue number 7, which was in case the encroacher of any government land is a non-farmer, can we encroach land?
9.07 page number, sir. Yes, yes, you continue.
Your Honor, this question has been replied by Mr. Bhavesh Patel, Deputy Secretary Land Revenue Department, who stated that encroachment on government land can be regularized as per the provision of yard dated 8th of January 1980 of the Revenue Department, and the procedure of regularization and encroachment is to be carried out as per this yard. Other than this, Your Honor, further states that furthermore, as per section 63 of the Gujarat Tenancy and Agricultural Land Act 1948, transferred to the non-agricultural. This argument
So point number 7, it says yes, it can be regularized. First page, point number 7. It says encroachment on.
यहाँ से start है furthermore as per section 63 ये transfer to non-agricultural part. What I'm saying is that all that through the permission you are saying.
Point number 7. So let your.
Yes, sir.
But let him remind he is now VC, but he is in court. So don't sit at leisure. Ask him not to sit as if he is sitting in his chamber. Otherwise, I will ask him to remain present before the court. Chalo, yes. Encroach, see point number 7. It says yes, it can be regularized by GR dated 8/1/1980. Now your next question. Okay, yes, you are right.
And evidence related.
Yes.
The statement of
Statement of.
PW 42, Your Honor. So, Your Honor, this is officer of Government of Administrative Department.
I know. इनके छेले आप ही दे दो डॉक्यूमेंट का पेज नंबर साथ में
The section 54 is and the state when circumstances which have been already that is also been considered.
Okay.
Thankful to my friend. The charge sheet says 54 of Saurashtra Act applies. And now my learned friend has shown this document to your honor. Where 63 of Gujarat tenancy and agricultural land applies. So and this 63 is not mentioned in the charge sheet at all. And that act doesn't apply at all to my district. And one question, very small question I am asking to myself.
Which act do not apply?
Sir, they just showed this table at D104, where in answer to question number 7, the Revenue Department says, furthermore, as per section 63 of Gujarat Tenancy and Agricultural Land Act, the transfer to the non-agriculturist is barred. Who is not? Otherwise, also I am saying that the transfer to non-agriculturist is barred. But none of them is saying that the regularization in favor of enclosure who is a non-agriculturist is barred. None of them. 42, 43, this query, none of them is saying so. Everybody who is, I am not denying, even 54, it says transfer is not allowed. The transfer is, suppose I am an agriculturist and my friend is not an agriculturist, I cannot transfer my land to this. That is what is barred. It is, sir, this whole act, this whole regularization, suppose there was an agriculturist, the purpose here is to help out a person who does not have, on one hand, my friend's argument is that he has to be poor, he has to be financially in a very bad situation and all those things. On the other hand, he is saying that he has to be agriculturist. So there is a dichotomy in the argument itself, fallacious. And can there be any, can the law be, if somebody says in the Revenue Department that Gujarat law applies to UP, will that be the truth? We are all legal people here. My London friend would have brought some law and said that this act, look, this act applies to this situation. This is not for the first time that the regularization is being done in the state of Gujarat. This is not the first case which has gone to the courts. I have clearly produced a judgment before your honor, which clearly says which law applies. Because this was the first question I asked him. That the GR doesn't talk of any law. GR doesn't say under which law, which act it is. His order doesn't say under which act it is. It only says GR. So I asked him under which law you are performing this duty. So that is how we got this judgment of Pancholi, where the court has said that it is under the 61 and 62 read with. It doesn't say Saurashtra Act. The jurisdiction is coming from a particular act. So what will have to be demonstrated to
But
this
then
order?
there would be one question.
Yes.
A person who is a non-agriculturist, then the land can't be allotted to him. Be it is Saurashtra section 654 or it is Tenancy Act 63. It can be self-transferred. transferred in any manner. Now then, your act
Pardon, sir?
your act of regularizing the land. Firstly, because he was an encroacher there,
That person is
encroacher. Then the land is allotted to a non-farmer,
correct.
non-agriculturist. So there are two things against that applicant. One, he is encroacher. Second, he is a non-agriculturist. And then also when the law prohibits of transfer, maybe by way of sale, mortgage, XYZ, how under which authority the land was transferred to these people?
I'll explain.
Because basic would be
The whole GR of 1980 draws an exception. It says that under certain circumstances, the collector is empowered to regularize in favor of the people. In this particular case, take example, the matter goes up to the High Court. The High Court does not say that since you are an encroacher, you are
see,
non-suited.
we will not go. High Court order was not, see, it has remanded to consider fresh.
Correct.
So it was to be decided, it has not given a verdict, either deciding any of either your side or the revenue side.
I will demonstrate that High Court has actually said something. High Court has said that you will not refuse it on the ground of public interest. So,
But then
High
also,
Court has gone a step further. It is not merely a remand.
but he was to decide afresh. He was to decide that application afresh.
Yes. Yes. The High Court says that you will now give them the hearing and decide the application.
So,
Now, what could I have done? Either reject or allow. So, the very argument now at this stage that they were non-suited because they were encroachers. It is implicit in the High Court order that you can allow. So, the question of being non-suited on that ground, the policy itself is for the people who are encroachers.
that order can be, it would be your argument. Impliedly it is said this way.
The GR itself.
So far as if your argument is pertaining to the Honorable High Court's order,
Okay.
yes, but it would be your contention, by implied way, it was directed to the, no, your argument.
I'm saying what I'm saying, sir.
But he was asked to decide it after giving hearing to everyone. So you were to decide.
I was listening to what IO sir was saying yesterday. कि साहब इस तरह से तो अगर जो लोग उन्होंने एनक्रोचर्स के फेवर में गवर्नमेंट लैंड देने लगेगा तो ये तो बड़ा गलत काम है सर. So what he is talking of is the larger thing.
No, that we are not concerned.
Here the government.
I am not considering that. The broad perspective note, we are concerned with the merit of the case. That's very much clear. I can't.
So, but
Yes.
my argument is very simple. There is a policy. Under the policy, the government has entrusted this job of regularization in favor of people who are there for a long period. High Court itself notes down that 60 years these people were in possession. And how it has to be done? By charging penal occupancy charges. The penal occupancy charges is not upon circle rate. It is not consideration. It's a penalty. So what is being imposed?
The penalty would come when the original applicants, they were holding the land by virtue of some orders passed in their favor on earlier occasions. which they might have breached.
The very fact that they are unauthorized occupancy. That is why the circular uses the word penal occupancy charges
But
or regularizing.
but occupancy would be on the basis of some, either their ancestor would have been given allotted loan by the then.
The circular itself says, the GR itself says that it would be in favor of the people who are encroachers. And it uses the term penal occupancy charges. Let me take this 122 of my compilation, if your honor has the compilation.
Page number, sir?
Page number 122 of my compilation.
Yes.
There were so many circulars and resolutions which are mentioned here. From 122, resolution this. Then it says the instructions issued in all the above mentioned resolutions, circulars and etc. are consolidated and following amended instructions are issued. So this whole GR deals with the issue of encroachers. So it says removal of the encroachers will be the basic principle. The very first line. No doubt about it. Then it carves out an exception in para 7. Regarding encroachments upon the agricultural land, para 6 and 7. Para 120, page 124. Page 124, para 6. In spite of the due care taken, there are encroachments upon the government land time and again. These encroachers are to an extent illiterate, helpless due to poverty and belonging to the backward classes of society. In my case also they are backward class. Such encroachments where the encroachment is 3 years or more than 3 years old as on so and so, such encroachment shall be regularized subject to the following conditions by the collector. So if it was prior to 72, it would be as a matter of right regularized, because so this is the policy of the government. Then para at 128, para 7, 128, sir. Para 128,
128.
128, para 7. For regularizing the encroachment upon the land not falling under instructions contained in para 6 above, if the land is encroached by any person other than backward class individuals, then at the time of regularizing the encroachment, 2.5 times of the existing market value has to be taken. So, as penal occupancy charges, if the whole, suppose, sir, let me ask myself, that suppose it was the intention of the government that a non-agriculturist should not be given. So many circulars, so many instructions, so many resolutions of the government are there. They could have said that no, it is not to be given. And I have, along with my compilation, produced orders where the revenue department has regularized
in favor of a non-agriculturist of the Gujarat government in 2022. And para 7, if you see the language, it uses the word any person. Otherwise, there would be so much of stress on agriculturists.
Any person, but it is exception to backward class.
Pardon?
Any person is an exception to backward class.
That to be para 6 then. Para 6, para 6, 96. Para 6 talks about just one thing. It talks about everybody, then it talks about para 7 that in case of people not in backward class, it will have to be 2.5 times bigger. As per the 125 para 3, if there are encroachments upon the 4 feet and other land that is entered into the government head for the reasons of each, if there are encroachments upon such developed land, then along with the lands under encroachment, the holding of the account holder shall not exceed 4 acres within such time and on payment of 2.5 times. Here you are talking of 2.5 times. The Shuni of categorize upon penal offense. So just give me one.
You also be ready with the point. That some proposal was sent for the acquisition of land by the forest. Whether your IO has investigated in that direction, whether that proposal was granted, rejected, who was the authority to grant, whether this particular parcel of land, it was to be given for the forest land. Then he was not authorized, he did not have power to regularize this encroachment. You just ask your IO and then you can revert back. Note down that point and then you can say, because your one of the contention is that the Mamlatdar had one of the objection was that it proposal to allot this land to forest land was also under process. Yes.
Sir, can I take you on to para 7 again?
In a moment.
Para 7. Para 7 actually talks about the backward also. The later portion. Occupancy and so on shall be recovered. Para 1, page number 128.
Yes.
In the middle of the paragraph. But from the backward class and socially and educationally backward classes, recommended by the Bakshi Punch on verification of their financial condition on recovery of not less than the original market value plus assessment and taxes from the date of encroachment till the regularization, the encroachment may be regularized. They are unable to pay such amount, then the proposal be made to the government for allotment of the land PO.
So it would be on the basis of recommendation by the concerned authority, that is Bakshi Punch. Now, whether there was any recommendation?
Recommended by the Bakshi Punch.
Yes.
And the educationally backward classes recommended by Bakshi Punch. So that classification is by Bakshi Punch of the backward
No,
classes.
the word is recommended.
No,
Re-
they belong to OBC, sir. OBC and SC. That is the IO's case also, that they are backward.
They are backward classes.
Yes. That is not in question. That is not even applicable. They are not backward.
No, they are backward, there is no doubt.
Yes.
So the para 7, it bifurcates, whether it is SC, ST, Bakshi Punch, ACBC.
It bifurcates in the general category.
General,
General category, it will have to be 2.5 times.
so for regularization, they have fixed some price as a penalty or.
Correct.
Now,
Right.
so far as backward class is concerned, it says who are recommended by the Bakshi Punch on verification of the financial condition.
Correct.
Now, while passing the impugn order, whether there was any recommendation or the financial condition was verified or not, it does.
Let me try. The Bakshi Punch really clarifies who are the backward classes. Now that is not even the allegation that they are not.
They are whatever they are polling.
So far as the valuation recommendation is concerned, it is the committee of the state and of the district itself, which is the district level committee, which has valued. There is no allegation that the valuation was wrong.
No, they have valued the land. Now you were required to ascertain what penalty should be imposed upon him.
Yes, that was the not less than the market value. The
Yes.
market value was assessed at 22 rupees. We have levied 25 rupees on them. So there is no allegation even that so far as valuation is done or so far as the amount recovered is concerned, there is not even an allegation that it was less or more. There is absolutely no allegation that the money which I recovered for the value of the plant as penal occupancy charges was in any way less.
Okay.
I could have gone to, suppose they had come to me that sir, we are not in a position to pay. Then I will have to go to the state government and ask them that sir, they are not able to pay, can we give it free of cost? So there is one more very interesting thing which has come out. Yesterday my friend argued that the whole FIR was registered at the complaint of the government officer named A.K. Rakesh. This is what was argued. Now kindly have a look at the charge sheet itself. Page number 47 of my compilation. Of my compilation. Para 16.2. Now, sorry, first let us read this. In the instant, first 16.1, in the instant case, complaints dated so and so, sent by A.K. Rakesh, Chief Secretary, GAT Government of Gujarat, forwarded through the Ministry of Personnel and so have been undertaken for investigation. So A.K. Rakesh is not the complainant. So let there be no confusion that A.K. Rakesh only forwarded 37 complaints against me. And in this case, the 3 complaints have been made by one Soma Bhai Patel MP. Interestingly, these one complaint in this case runs into 28 pages. It is kind of a, if Your Honor will have a look, it is D60, Your Honor will note down. I'm just giving the copy also. It is actually an appeal or a revision. And the copies of this complaint, it is addressed to the Prime Minister of India, and the copies have been sent to almost every person in the country. I'm just Your Honor will see here all here sent the copies at last 2 pages. It starts with Honorable Home Minister, Government of India, Honorable Chief Minister, State of Gujarat, Honorable Chief Justice, Gujarat High Court, Deputy Chief Minister, Home Minister, Honorable Minister, all Ministers of State of Gujarat, Chief Secretary Gujarat, DGP Sahib, number 8 is Additional Chief Secretary Revenue Department. So he sends it way back in 2021 to the Additional Chief Secretary of Revenue Department and to all IAS, to all IPS, to all ministers. In last 5 years or 6 years now, no one found an occasion to revise my order. Kindly see that this particular, such a detailed complaint, obviously drafted by a lawyer, talks about all the legal issues. I am not getting into the question whether it is motivated or not, because that is not the question to be decided right now. But for one particular fact, that it has gone to the Additional Secretary, Department of Revenue, Additional Chief Secretary, sir. So if the Department of Revenue Gujarat thought they have, IO Saab has recorded the statement of a section officer, of a chiefness, of a mamlatdar, to tell this honorable court what is the law. Here is a CC gone to the Additional Chief Secretary. He could have investigated that what did you do? Why did you? It is a revisable order. They could have called for the records of this matter. One of their allegations is that I did not forward the copy, but Soma Bhai Patel forwarded the copy with all his issues, all these points. But no one in the government, from Prime Minister to the Mamlatdar, Angad, have made a complaint about it, except for Soma Bhai Patel, who makes 37 complaints against me. And sir, there is one more very, very interesting issue here. This whole complaint, this whole FIR is based on this complaint which I have just now given the copy. And Soma Bhai Patel is not cited as a witness before your honor. he does not find mention as a witness. Thankful to my friend that he opened my eyes to this aspect. Yesterday, by saying that it was the complainant was A.K. Rakesh. The complainant here is Somabhai Patel. And his statement, or he is not cited as a witness here. How will this case be proved? Ever? If you are under fixed charges. The complainant is not going to come in the witness box. And sir, the complaint is of gratification. The complaint is of gratification. Complaint is not that I passed an illegal order. He actually in his complaint alleges gratification. With all due respect, the complaint ought not have been entertained because it does not contain verifiable facts. It's just in the air that he is saying some gratification has been taken. He could have said, he could have just gone to the revenue department and said, government of Gujarat, and said that he has passed the wrong order. Please revise the order. No problem. But when he talks about gratification specifically, he says he has taken gratification. He ought to give some evidence, some fact, which is verifiable in nature. And you don't cross-examine him, you don't cite him as a witness, because you know that in 1 minute during the cross-examination, he is going to fall. He is not a witness. How can this case proceed any further? Once the complainant himself is not a witness. And sir, kindly see, again I am just troubling your honor to come to the same paragraph of the charge sheet, sir. Page 47, sir. Page 47 of compilation. Para 16.3. The allegations leveled again above said complaint against Rajesh, the then Surendra can be categorized as under. So he is categorizing 37 complaints. Here, number 1, K. Rajesh has demanded and accepted illegal gratification for issuance renewal of arms license. So, case number 3 was instituted for the saying that I took money in arms license. 2. K. Rajesh has demanded and accepted gratification for allotting various government lands, plots for sanctioned revenue entities to unentitled beneficiaries. So he has not found any, either he has not found any evidence or he has not found any criminality in any of these complaints or allotment of them. Then comes the 3, which is our case. K. Rajesh has demanded and accepted gratification for regularization of illegal encroachment of government land to ineligible benefits. So my case will fall here. The investigation was kept pending for looking for illegal gratification. The prosecution does not even talk about illegal extraneous consideration or gratification in the whole charge sheet. To make out a case either under 409, right, 405, or under PC Act, they will have to show some just my illegality of my order. Let me presume that my order is. It rightly fell from this court then this court will not start exercising the jurisdiction under the revenue law. Or the prosecution can't sit and appeal over the revenue over my orders. And there has to be a presumption of bona fide in favor of the collector, unless proved otherwise. And that presumption, that is very, very strong. The other day I gave the judgment of Ajit Nag, where the court says, Supreme Court says that if you have to allege malafide, the onus is very heavy on you. It can't be based on inferences. This is my 43rd year now starting, sir, in profession. I have seen cases, Your Honor has seen cases where the trial court gave a judgment. It was set aside in the first appeal. It was again made in the same as trial court in the second appeal. Then Supreme Court did the other way around. We have seen cases. Does it matter? Unless malafide is shown, that is the primary requirement of any criminality. And you hold for 3 years, you hold the investigation on this ground that we are looking for illegal gratification. In the whole charge sheet, you don't even allege that there is any gratification. While the complainant says that, you hold back the whole thing on that ground only. So my very, very respectful submission is, sir, that even if we presume that there was some illegality in my order, number one, it is not illegal because the authority who has the power to say so has not interfered. I have given the judgment to this honorable court that I was exercising the jurisdiction under section 61, 62, read with 1980 GR of Land Revenue Code. I have given the judgment. There is appeal provided, there is revision provided. The government would do it suo motu. So when the authority which has the jurisdiction to do that, which has been bestowed with the duty with that, and we have the document to say that way back in 2021, that authority was aware about it. And that authority has not interfered. So it will be stretching it a little too far if we get into this aspect. When I took your honor through every allegation, what I was doing was just to explain that it was not malafide. There was no malafide. I mean, I don't know whether those people, these landless people, what would I have taken from them or what I have taken from them? Just maybe I became, मेरे को दया आ गया सर बहुत ज्यादा, मैंने चल यार दे देते हैं, मैंने गलत कर दिया. But who will decide it? You need to have some very strong evidence. You can't ask this court, you can't pray to this honorable court to say that please infer. We all know what is circumstantial evidence, how the chain of circumstances has to be completed. There cannot be a single loophole in the chain. Even if there is something to doubt in the whole chain, the whole case will come up. Here there is no chain. You are just picking up stray things and you are trying to say, presume sir, presume sir, presume sir. In fact, my learned friends' arguments were that. That is presumption. It will rightly fell from this court, then it will be impossible for any officer to work if in this fashion. Because exercising any executive, judicial, quasi-judicial function requires a bit of boldness. Requires the feeling that, look, if I do it bona fide, if I do it with good faith, maybe my order is wrong or right. My appellate authority will take care of. My appellate authority will tell me whether I am wrong or right. So you please do it. And the charge sheet doesn't say anywhere.
PW 43 cabinet. PW 43.
Yes.
Yes.
But, I feel that this honorable court has given us a lot of intelligence and very, very patient here. Only to assist this honorable court, we will give about 10-page submissions.
in this case.
in this matter for written submissions.
Okay.
So, and thereafter, we will leave it on this honorable court. Because it will be just stretching and re-arguing the things only.
You can mention your points. I already noted your points.
Everything has been noted down by your honor.
So you will specify one thing. What is the prima facie evidence collected by you during investigation about attracting ingredients of section 13? One thing. Second thing, on the basis of whose statement you arrived at a conclusion there was some malafide on his part. One thing. Whether it is coming from the statements of the applicants who are now accused in this case, or whether some other person has said something, be it a revenue officer, be it other witnesses, on the basis of which you have arrived that he has illegally gained something. So go through you can have a discussion with your IO and you will say. And secondly, you will specify that whether your case is on the basis of 1980 GR or whether it is on the basis of tenancy. Yes, he was barred, he was not having jurisdiction. And you will also, given none of the orders have been set aside, they have been taken into revision. No, don't go by your knowledge, go by the record. We don't want to go anything because prima facie this would be the first thing. And whether the very basis on which the complaint has been initiated, as he contended, on the basis of the Somabhai Patel. So his contention is that he is not a witness. And then your charge sheet and allegations in the charge sheet. Illegal gratification, malafide in passing such type of orders, and various instances which you have clubbed in these two cases. And during the period of 3 years, did you find that whether some illegality in the order, that would not be your jurisdiction to decide? You may say this is a wrong order, but unless it is said by the concerned authority. Now, malafide, then there should be reasons which would fall in your jurisdiction during investigation, what malafide was there and what he has gained. And secondly, those persons, whether they were already enriched people or not, and land has been allotted to a very cheaper rate to a non-farmer. Maybe there might be many instances as you are arguing, but then there should be evidence. It is not a new thing that under the guise of passing of the orders, many things are happening, but then there should be an evidence. There are instances where non-farmer is made a farmer, then land is been allotted, but then there should be evidence under why it was that done. Now, whether this applicant falls under those categories where the powers are malafide exercise, that you will have to point out from the evidence. Your submission or charge sheet, it should be based on the evidence. Just point out that thing. Only that point only will point out. Rest of the things are argued. So you can have your conversation with your IO. And you can file your notes. But then if Somabhai is examined, why is not a witness? If he is not examined, then why he is not examined? You are representing the IO. You can't ask me that you ask to the IO. If I find, then I will call him personally. But you can ask your IO. He is also here. You can convey him. And don't suggest me that you ask to the IO. You are here for the IO. You are here for the CBI. Your request can be unreasonable. You are counsel representing CBI. And you are also equally responsible to assist the court.
Sir, you will also do the writing and I'll also do it. Or will it be again listed?
No, now it won't be listed. Your hearing is I will give a date. He will say, okay, this is the thing. You may give your points. If you find to respond to that, then it's okay. Otherwise, this, so far as this 33 is concerned, it is now arguments for discharge are concerned.